Well, I want to first say welcome to everybody. I know we have some people joining us from Earth Law community whom I don't know, and we'll all get to know each other soon. But I'm Carrie Cass. I am the co-director on the Center on Dispute Resolution for the law school, which is the host entity for our integrative law program. And in fact, we have launched a project on integrative law in legal education late last year. So, other than that, and many of you who you may or may not have already met Aubrey Davis, who is our center fellow, a rising 3L, and she's here to assist us with all things technical as well, and to sort of staff this meeting. And you're going to meet, I assume, Tony, you're going to have everyone introduce themselves, so you'll meet our other people. We are aware that this is being recorded and that there are some people who wanted to be on Zoom for this program and are unable to, but will be listening to it later. But still, we should come together as our community of people here as well. But we're very happy to welcome Tony Zelle to this program. And Tony, turning it over to you.
Well, thank you very much, Carolyn, and thank you to the Quinnipiac University Law School community, which I have found since the launch of Earth Law as an educational process is really supportive. I'll let them introduce themselves in a moment, but Richard was an intern for the Earth Law Center. Carolyn took the summer class, our pilot summer class, as did Carl. And yeah, we welcome you to the revolution. Now, because I said revolution, that reminds me to say that the opinions that may be expressed are entirely my own and shouldn't be attributed to the Earth Law Center or anyone other than me. So I'm going to share. Are you sharing screen, Aubrey, or am I sharing?
I don't have it pulled up, so.
All right, I got you.
Okay, perfect.
All right, hold on here. I'm looking at, oh boy. All right, stop share. Give me a second. We were so tuned up a minute ago, you guys. Oh boy. All right. Here's my PowerPoint. Here is the first slide, and now I can share. So there's two types of people in the world. The type of people who describe exactly what they're doing when they're clicking buttons, and some who don't. I'm in the first category. All right, I am sharing this screen. Share. All right. Now we're going to put this into slideshow mode. Yes. Yay. Maybe. Yay. All right. So I'm willing to set the bar pretty high, as you all can see. I'm also an alumni of the class in 1981 of the University of Minnesota. So yeah, I was not all that thrilled in this achievement by Quinnipiac University, but I will be thrilled because I believe that Quinnipiac University Law School will be a leader in Earth Law education and that the students will become leaders in Earth Law. This is the Earth Law theory of change. I love it when acronyms work out, and in this case, they did. It is an inspiring theory of change. I also have reduced it to 4 words: consciousness-altering systemic change. Consciousness altering is obviously a subjective thing. We as human beings can alter our consciousness. And through the individual recognition of new paradigms, I'm certain by this point in the class you understand the importance of paradigm shifting. When we recognize that new paradigms provide us with the opportunity to think differently, to think more creatively, imaginatively, that is what leads to systemic change. Inspire are the core values of Earth Law. Inspire, not coincidentally, is a word that derives from spirit, has related words of aspire and, of course, expire. And Earth is a process. We are all part of the process of emerging. We are all interbeing, meaning whatever. Geez, I sure hope I'm not frozen. Am I frozen? Oh no. Hey.
Tony, your
You can't-
voice is fine.
Okay, good enough. Now what did I do? All right, can you see the screen? All right, cool.
Yes.
So interbeing, this is a concept, the concept of the politics of being. Is one that is really fundamental in the work of the United Nations Sustainable Development Initiative. And that initiative is also an author. His name is Thomas Legrand. And he speaks of interbeing. Interbeing is not a new concept. It, in fact, relates back to many indigenous worldviews, cosmologies, where the way we are is always in relationship. Ubuntu is an African term for this concept that we are always we are in relation. We are reflected, we are as we are reflected through other beings. Nature is one. This is a fundamental concept. Richard will address it a bit, but our culture has adopted a cosmology that has been described as an ontology of separation, one in which humans is one thing and everything else is beneath us, is different, and we are the only ones imbued with the spirit of the universe, the spirit of the earth. It's the reconnection with this spirituality in any way we might connect, a walk in the woods, meditation, a religious institution or community. Spirituality is going to continue to fuel the development of Earth Law. Indigeneity, you will see how important this is as we discuss this cultural and biological transformation from Homo sapiens to eco-sapiens. We must really reimagine and reinvent what it is to be human and what is a human being. This relationality is the human being is so focused on relating to other human beings and corporate beings and national and state and local sovereign beings. Our relationality to nature is obscured. And as you will see as we discuss the cases and the practices of Earth Law, it is emergent, and it is emerging at an ever accelerating rate. All righty. Oh, there we are.
Hey, Tony, why don't you turn off your camera for a bit?
That's probably
And because we can hear you just fine.
good. All right.
And then maybe when you turn it on later, when we're all talking, your picture may come back.
That sounds cool. Unfortunately, can you hear me now?
Yeah.
Okay, good, because I've got the little spinning thing. So, all right. Poor internet. I'm so sorry. Zoom meeting is not responding. All right. Don't dare to,
Or
unfortunately.
if you don't want to
I'm
mess
frozen.
with it,
I'm sorry.
we can hear you fine. It's fine.
All right. But you don't have the, do you have the PowerPoint?
Yes, we do.
All right, then. If you don't see me, that's quite cool. I'm not sweating, just in case you were wondering.
Okay, good.
Now, how is Earth law an agent of change? Well, our motto is making Earth law and making Earth lawyers. Making Earth lawyers is exactly what Richard is all about. He's learned about Earth law and now he's going to teach Earth law at Siena University. It's a major ambition of the Earth Law Center to promote global education so that students all over the world and practitioners as well as lay persons, as well as those institutions that might be willing to promote this. This is who we're appealing to through education. And, Earth law is an agent of change, and our motto is making Earth law and Earth lawyers. The ways we are doing that are through education, and Richard's a prime example, teaching at Siena University in the fall. Movement lawyering, we're all familiar, I expect, with grassroots movement lawyering, and we are also at the Earth Law Center driving movements from corporate boardrooms. We have a Nature on the Board project, and through that project, we're training proxies to speak for nature as directors for corporations. The rights of non-human nature, rights of animals, rights of plants, rights of ecosystems are all areas of Earth law practice. Rights of future generations, atmospheric trust litigation is one of the tools that has been extremely effective in establishing and implementing rights of future generations. The Juliana case is an example. I would expect that even environmental law courses would introduce that case. The public trust doctrine, an ancient Roman doctrine that imposes on the sovereign the duty of a trustee for the beneficiaries of, namely the citizenship, is an ancient concept that's coming back into play and is the root of the atmospheric trust litigation. The climate necessity defense is a nice little tool. The necessity defense is one that's been codified through common law since really early English times. And the elements of the defense are limited. All one needs to prove after pleading to the prima facie case of typically vandalism or tortious interference, the climate necessity defense says if you can prove as an affirmative defense that you have prevented more harm than you have caused, you will not be, you will be acquitted. Nature governance, I spoke of briefly. What we are working toward is a new ecological social contract. And we have been living with a social contract that emerged in the 17th century. And I think most of us, with even the tiniest bit of insight, will recognize that that contract doesn't work anymore, that nature and the earth have to be parties to the new ecological social contract. So whose slide, if we can go one more slide, I think we got a book cover. So this is the work of hundreds of people and thousands of hours. It was an interesting beginning. It began when my colleague Grant Wilson, the director of the Earth Law Center, was waiting in line to get a cup of coffee in Boulder, Colorado. And he met an editor for Wolters Kluwer's, the publisher, and struck up a chat. And the editor said, "Give me a pitch," and we did. And here we are. a book for students and practicing lawyers who seek to preserve a habitable planet and question whether current environmental law is enough for the task. Next slide. We break the book into these 5 parts. I've broken this lesson into 6. The emergence of Earth's law and fundamental concepts, threshold challenges, such as property law and private ownership. And Richard will touch on those topics. Litigation strategies, Carolyn will share some of those in further detail. There's one more point about nature governance that I will share. And then I'll talk about some of the Earth law emerging around the world. And if we have time left, and I expect we will, because as I said, this is Earth Law 101 in 30 minutes, we'll have 10 minutes for conversation. Next slide, please.
Modern environmental law paradigms were developed as a response to the end of the feudal period. After the unprecedented and horrific Black Plague, which killed half of the European population, individuals began to raise questions about the fundamental assumptions of their worldview. The church had previously been the ultimate authority over the people, but a combination of the institution's failure to prevent mass casualty, a rapid turnover of property and inheritance, and an increased value of labor among the working class led commoners to begin questioning if their allegiances had been misplaced. In the following century, the printing press and the scientific revolution gave workers the tools for self-determination. Liberty, human rights, and material progress drove modernists, and with the power wrenched from the feudal lords and the bourgeois, they created the concept of private property. During the Industrial Revolution, however, it became clear that private property was much more than a hallmark of self-determination. It was also a tool that could be used by opportunistic industrialists to profit at the expense of the environment. Property law protections like nuisance were wholly inadequate to deal with the scale of the pollution, culminating in ecological catastrophes such as London's Great Smog, Minamata's widespread mercury poisoning, and Cleveland's burning river. As a response to the tens of thousands dead in the wake of these triggering events, the UN held a summit on the environment, proposing a framework for ecological stewardship that today has manifested in environmental law. Unfortunately, in the 50 years since that summit, the global environmental project has all but dissipated. The profit motive and the overwhelming global consensus towards infinite growth and wealth accumulation has made ecological stewardship all but impossible. However, just as the triggering events of the Industrial Revolution manifested in activist demands for a stable environment, the looming crises of climate change represent a similar opportunity. This time, we must ensure we develop a movement divorced from a profit motive, one that discards cost-benefit analysis and embraces a philosophy of shared responsibility and benefit. Earth law is that movement. Modern environmental law.
Awesome. So I'm going to take over from here for the next couple of slides. Thank you, Tony, for inviting me to come and speak. It's really went full circle. I graduated Quinnipiac Law School just last year, and I interned with the Earth Law Center. I was the first intern from Quinnipiac University School of Law in 2021. So I started establishing that relationship. And now I work at an energy trade association in New York State that represents the highest percentage of clean energy in New York. So once again, thank you, and I look forward to bringing you through the next couple of slides. So starting off here, we're going to go over some fundamental concepts of Earth law and kind of how it differentiates from the classic traditional environmental law that was created in the 1970s, such as the Clean Water Act and the Clean Air Act. So Earth law is a departure from environmental law and a new context for its extension. So not only is it a new way of looking at things, but it's also a way of using existing tools and legal frameworks and kind of pushing the boundaries of where they've been able to take us in terms of protecting the environment. Legal systems as a whole have evolved from localized customary laws to modern Western legal systems based on separation of humans from the rest of nature. And this duality, this either or, is kind of what Earth law is trying to get rid of, instead of having an anthropocentric way of looking at the law. We're trying to get the environment and the Earth to have a seat at the table some would say, kind of be part of the process of an entity that can help protect itself and have a voice. This ecocentric jurisprudence for protecting life on Earth is based on concepts of interdependence, entanglement, reciprocity, and mutuality. And all of these is kind of a legal philosophy that is explained in Earth Law, the text, as Tony was describing before. And kind of how it's kind of like an ecosystem, how the entire legal system could benefit from having this center on it of the environment and the Earth as a player. Many of these concepts have been practiced by indigenous peoples since time immemorial, and in more recent centuries by island peoples. And so going back, I think what's key to this and kind of why we're here as part of the integrative law foundation and framework is that these indigenous peoples didn't think that they had a role in using the land for their own benefit, but kind of living with it and being a simultaneous partner in fostering the land and caring for it for future generations. And so making a legal movement around that is key. And going back to that kind of framework. The connection with the land, the waters, the plants, animals, and spirits is ingrained in human cultures and belief systems. And we've seen this in recent years with humans kind of saying that they're not religious but spiritual, getting away from the institutions and kind of into what makes us all human and the humanity of living with the earth as a partner rather than as a way to exploit for human benefit. So these are just some of the fundamental concepts that Earth Law is centered around. So this slide is a quote by John Locke, a famous political philosopher. And it says, "The state of nature has a law of nature to govern it, which obliges everyone, and reason, which is that law teaches all mankind, but who will but consult it." And so John Locke, who wrote the two treatises on government, believed that sovereignty resides in the people and explains the nature of legitimate government in terms of natural rights and the social contract. And really what he was pushing back against was the authoritarian form of government or top-down structure, where one person and one institution would rule and whatever they say would govern whatever laws they promulgated. Instead, what Locke did is he said, look not to authoritarian government, but find the truth and governance through the self and nature, through introspection and through partnership with the world around you. And so that kind of political philosophy, all the way from the 17th century, is kind of what's driving Earth Law to where it is today.
So thank you, Richard. That's I need to commend you. This is a slide that was part of the slideshow I put together, and Richard said, I'll cover this one. And I was a little bit surprised, though now I'm not at all, because he clearly understands the conceptual framework of John Locke that's, some would say, have started us on this horrible trajectory. Obviously, it didn't start out so badly. The reason I included this picture, this is a photograph I took of myself. It's on the Loveland Pass, which is right on the Continental Divide. And about a half an hour earlier, I had seen the sunset on the other side of the Continental Divide as I was driving west. And I was looking forward to getting to the top of the divide and seeing the sun again. And when I got up, I listened. I thought about the connection with land and waters and plants and animals and spirits that's ingrained in human cultures and belief systems. And orienting myself, I heard the sun say, "Come play hide and seek." And I ran up a slope and down the other side and got to see the sun setting as I went down. And I ran up again, and there was the sun setting, and I went down to see it once again perched on the horizon. And I tell this story because we are all capable of playing with nature. Perhaps your parents told you, go play with the ocean, but more likely it was go play in the ocean. We can play with the wind and fly a kite. Certainly we can play in the water and become become capable of three-dimensional motion. These are the spirits of Earth that we can all connect with. And I submit that modern education tends to drive playfulness out of us. And it is up to us now as adults to reclaim that playfulness. I think you've got the next slide, Carolyn.
Do I?
I think I might have one more.
Oh, one more for you.
Nope,
Richard.
I got one more, and then I pass the
Right
gavel
on.
on. That was a great story. Thank you. So some threshold challenges for the development of Earth law are kind of based on the traditional legal principles. And this is a duality of what I was talking about between an anthropocentric worldview, that's kind of the traditional legal system, and the ecocentric, which is what Earth law is trying to achieve. Ecocentric environmental law also gives high priority to human needs, but considers rejecting the thinking that human needs and the needs of nature can be separated. Instead, they have to be seen as coexistent. So the threshold challenges involve how the various aspects and dynamics of nature might be taken into account in a human legal system. And the barriers include property law, standing, and guardianship. As far as property law, nature belongs to the owner of the property that the nature occupies. So instead of seeing it as humans owning individual plots of land, right, and that's kind of what the video is going into after the feudal era and the rise of individual private ownership of land. Instead, nature is the owner of that land, and humans are meant to be the guardian of it and kind of foster it for future generations, not to exploit its resources. And that's a very big dynamic of changing of thinking, really, from traditional law. Standing, I think we can all remember back, if you've taken environmental law, to the classic Sierra Club case, where the Sierra Club sued for, what was it? It was animals in Africa that were going to be harmed. And the court in the US said, no, you don't have standing. And that's kind of the hallmark case of you need to have a stake in the what's it called? In the fight, right? You can't just be a random person saying, no, I am a lover of elephants. I am going to protect them in Africa because that is the right thing to do. And so what Earth law aims to do is to give that standing through giving interests, legally protectable interests to natural entities, such as rivers or streams or ecosystems, all of this. So the interests of nature and posterity or future generations are not represented in law in their own right, but only as resources for use by legally recognized persons. And then finally, guardianship. So what Earth law is doing is not only is it giving these natural entities its own protectable interest, but it's assigning a guardianship right to a set of people or a person in order to monitor and to report out and to have the right to sue in court in the traditional legal system if those rights are being violated. So these three traditional areas of law were challenges that Earth law seek to overcome in order to be able to fulfill its mission. And with that, I pass it on to Caroline.
Thank you
Thanks
very
so much,
much.
Richard.
Thank you. Also, I'm very happy to be here today as well. Caroline Reynes. I also am a Quinnipiac law graduate, and I came to Earth Law through the summer internship program because a fellow student had advertised that it was a virtual opportunity. And at the time, I had small children and it was COVID and I needed a virtual internship, but I had never heard of Earth Law. I had heard of environmental law, and I was able to take an environmental law class at Quinnipiac with Professor Pavetto, who's on this call. And I believe Richard was in the course as well. And I always tell the story, you look back at your childhood and your children's childhood, and we didn't have Earth Day when I was in school, and I didn't really think about Earth having its own rights. So I was absolutely intrigued. And since then, I had taken Kim Wright's Conscious Contracts and her integrative law courses and her clinic. And I said, you know, I have to introduce Tony and Kim to each other because I felt that the two of them needed to meet and there were some concepts that were overlapping that would be great for one another. And was very much encouraged to get into my local town politics, where I now do inland wetland watercourse commission work, and I'm on some environmental committees. So that's how I came to be here. And I'm very excited to share with you some earth law litigation strategies, which are to extend the reach of the law to grant protections to not only the earth and its systems, but also to recognize that these systems support human life. So there is the public trust doctrine, which Tony had touched on a bit before. It originated in Roman law. And this is the concept that the public actually has a right to natural resources. No one owns the air, water, sea, or any seashore. And in the United States, mostly we think about this when we talk about lakes and streams. And an example that's often given is that a person in the US cannot own any part of the ocean. So I always like that example. Then there's the rights of future generations, which also Tony had touched upon. And this is a relatively new area that's really being vocalized. It not only extends to global warming and other environmental changes, but in relation to earth law, I think we can look at things that are going on around us. I like the example of what's happening in the West with Colorado River and how it's just drying up. And what does this mean for future generations? What does this look like in the future? And can we consider the right of future children, generations, to be able to access this water, to have clean water, and to benefit from the river in this water? Then there is the rights of nature in the United States, and that nature has a right to exist. And this theory challenges the relationship that nature has with humans and advocates that everything in nature, whether it's a mountain or even a valley, has just as much rights as a human being. So nature is its own entity with distinct rights that are equal to the rights that a human has. Then co-violations. I always find this to be a very interesting area of human rights and the rights of nature, in which we recognize that governments, corporations, and industries are threatening not just human rights, but environmental rights. And this also includes the indigenous peoples and people who defend the rights of nature. And then, of course, there's non-human rights, which pertain to living beings other than humans and advocate for things such as fairness, autonomy, and liberty, even for these non-human beings. And ecocide, which I think of, I'm sure most of us think of, those destruction of the rainforest, right? We see those very moving and touching photos or videos of the entire ecosystem just being wiped out. And then the climate necessity defense, which Tony had touched upon. Sometimes I like to think of that as the choice of evils defense, which is also another term for it. And it utilizes, of course, that the defense that actions made on behalf of the climate or earth is associated with civil disobedience, and that we're going to use this defense because our actions aren't, in fact, illegal, but rather needed to avoid greater harm. And an example could be, someone blockading or protesting fossil fuel extraction. And we had seen some of that out west recently. And of course, then there is nature governance. And this would be like nature on the board of a corporation where there's a non-human stakeholder model. And actually the Earth Law Center and Lawyers for Nature helped to create this very first ever board seat. And it allowed for a representative at a beauty care company called Faith in Nature to solely represent the interest of nature and sit on that board of that company and say, well, wait a minute, how about nature? How does nature fit into all of this? Which I also felt was very unique and something that I think is really going to take off in the future. And I know that the Earth Law Center in training and our class over the summertime, an internship often talks about how it can help other companies do the similar, take a similar path.
Thank you, Carolyn. And I want to just go a little bit deeper into nature governance. And so if we can advance to the next slide, Richard, there we are. When I first heard about Earth Law Center about six, 7 years ago now, nature governance was the farthest thing from my mind. When the book was put together in 2019 and 20, there's no mention of nature governance. I expect many of you have heard about ESG, environmental, social, and governance metrics, which the market, the financial markets use to measure the commitment of companies and the evolution of companies toward better environmental, social justice, and governance practices. I did not really think, and was cautioned by the prior director of the Earth Law Center, a fantastic activist named Linda Sheehan. Don't talk to corporations, don't take money from corporations, don't trust corporations, and don't engage with anyone who works in that context. And, I followed the rules for a while, but I've completely come around to think that in the spirit of consciousness altering systemic change, if I'm speaking with another human being who might be interested in altering their consciousness to recognize the fallacy in the human nature divide, then I would talk to them. And more to the point, I'd charge them for my legal services. And that's not really more to the point, but it became an opportunity, of course. And my colleague, Alexandra P. Moore, has been developing this in concept. And these are the key questions. What is nature? Are we nature? And it's pretty simple in a corporate boardroom to, particularly if you're sitting around a wooden table, to say, well, this boardroom is nature. Everything that came to put this boardroom in place for us to meet him came from nature. We, of course, as humans, are nature. And the only unnatural thing is this corporate entity, this corporate personhood through which we are able to act. And through this corporate being, we can make profits and we can divide ourselves from the moral responsibility that goes with the corporate decisions. And if you've taken a directors and officers course or a course in corporations, you'll understand that the corporate shell was created to basically enable human beings to profit in ways where their ethics wouldn't permit them to do that individually. Of course, nature should be included in corporate and organizational decision-making. And what nature governance involves is human beings as proxies for nature. Now, I don't feel qualified in any way. And it's not humility. I am just completely inadequate, I expect, to represent the interests of nature. But I'm going to learn how. And I'm learning how through these client engagements that the Earth Law Center has with Faith in Nature, with another company called Thistle Rock Mead Company. And it's very different challenge with Thistle Rock Mead Company and Faith in Nature to try to bring the voice of nature into the boardroom than it is with Coca-Cola or Nestle's. Nevertheless, I spent 3 days at a conference called the Association of Corporate Counsel. This was a European conference, although they have a US base as well. And these were chief legal officers and general counsel and chief sustainability officers and the people whose jobs required them to take care of nature. And they were extraordinarily receptive to this idea. And there was a point in this conference, a plenary session with 200 people, and there were 3 financial analysts on the stage with a moderator. And the financial analysts very persuasively explained why corporate beings will not continue to make profit unless they commit to environmental and social and transparent governance goals. That was the only way they would make profits, because shareholders were going to demand it and the market was going to demand it. As I said, it was persuasive. I knew the moderator, and I asked him if he felt comfortable to pose a question to these financial analysts at the end of the session, and he did. And he asked them, if there was no profit motive, would there be any reason whatsoever for ESG? And what the audience of 200 saw was 3 deer in the headlights. This was something that simply didn't dawn on this audience of corporate legal counsel. What I learned through this conference, engaging with people individually, was that many of them are doing it for the right reason. It's because we want the earth to continue to be habitable by human beings. And as it becomes less habitable, they will become less interested in the convenience of fast food and fast moving consumer goods. And they will become much more reluctant to pay $6, $7, $8, $10 a gallon for gasoline. And the most important lesson that I learned was that these executives and officers can drive movement building, earth law movement building from the top through rigid hierarchical structures, despite the appeal that I find in flatter organizations. The strict hierarchies of megalithic corporations permit change to happen quickly. Next slide. Oh, I do want to read this poem. Jojo Mehta is a young woman who is spearheading the ecocide movement. And if you're aware, you will know that it is going to be proposed at the next conference as an international a conference at the International Criminal Court as the next international crime, along with genocide and war crimes and other horrible, horrible crimes. Jojo wrote in remembrance of her mentor, Polly Higgins, imagine a future where the principles by which the world operates are golden rules. First, do no harm. Second, care for all. And third, seek joy. If you were able to see in the shadow in the photograph of me against the mountain, my face, I'm certain you would have seen the joy that Jojo's writing about in Dear Dandelion. Next slide, please. So I've got 1 minute and I'm going to whip through this global Earth law developments. I don't know the geographic or national makeup of the participants in this integrative law course, but I assure you it is emerging everywhere. Ecuador, of course, was the first country to pass a constitution giving rights to nature, Pachamama. Colombia has recognized the rights of nature. And in particular, that law was implemented in a court case in which the Atrato River Basin's rights were affirmed, and as a result, destructive mining and deforestation operations were suspended and ultimately prevented. In New Zealand, the Te Uera Act recognizes a national park as a legal entity, and as importantly, it is an entity whose proxies are not only the national government, but the indigenous community as well, the Maori people. Another common law decision by a state Supreme Court in India recognized the legal rights of the Ganges rivers, as well as rights for the entire animal kingdom. The proclamation of rights is only the beginning. The legislation is only the beginning. It is how the law is implemented. And regrettably, in India, the decision was overturned because the court simply could not contemplate how the river could exist as a party, as a respondent or a petitioner in the Indian judicial system. Some other global earth developments in Mexico, 3 of the state governments have included rights of nature within constitutions. Again, it's all about implementation, but it becomes law in the contemporary world when it is written. In the indigenous worlds that continue to exist today, in ancient worlds of human civilization, law did not need to be written. It was customary, it was normative, it was enforced by behavior. Bolivia has adopted the law of the rights of Mother Earth and a framework law. Brazil is recognizing non-human animal rights. And in the Netherlands, in an atmospheric trust litigation case, the court ruled that the government owes a duty to both present and future citizens of that country, the government meaning the legislative and executive branches, to comply with CO2 emissions established by the European Union's Convention on Human Rights. So I would throw it open. We're a little later than I expected. We've got 8 minutes if we want to engage in some conversations. This picture you might recognize was taken in Central Park, in this oasis of trees and water and rocks and living organisms, against the backdrop of steel and glass and concrete. The question I pose is that nature? And I'll turn it over to my co-presenters, Carolyn and Richard, for the first 2 comments. And please feel free to comment on anything you've seen in the presentation, or take my lead and tell me whether you think that's nature. You want to go first, Carolyn?
She froze.
Nope. That's a hard no. I guess then Richard, it's you.
She might be frozen. I was going to let her go first.
Oh, here we go.
There you
Hi,
go.
Sue. You're back.
Am I back?
Yay.
Yay!
You're back.
Okay, I'm getting thunderstorms and unstable internet, so I think I'm going to turn my video off. I say yes, it's nature and a beautiful scene.
And what about the steel and concrete and asphalt? How does that fit within nature?
Well, I wouldn't say that was nature, but the nature was here before the steel were here, but they're coexisting.
All right. Richard, take a swing.
I think it's nature, but it's not natural almost. You know, there's that duality of what is human and what is nature. And I lived in Copenhagen for half a year when I was studying undergrad. And they did a real good job of kind of putting nature back into cities and not having that sharp line, that sharp divide. So I would say kind of no. I would say that if it has that sharp line, then it's meant for human pleasure rather than meant for the earth's good.
Carl, you got a thought?
I actually can't see it. I'm using a tablet and I couldn't
Okay.
see it, so I can't see the picture. But I fully trust my former students, Richard and Carolyn, and you, Tom, to have portrayed the picture. And
So here's the analogy I tend to explain in this context. When a beaver builds a dam, it's generally going to be understood as nature. And that's awfully destructive. There are trees coming down. There's a river being dammed. There's the fauna and flora and on the river bank that's going to be washed away. It's great for the birds. Some of the birds that'll feed on the fish that are going to be a lot easier to catch. Not so great for those fish. It's good for big fish, but not so good for little fish. So in this reasoning of nature being both destructive and constructive at the same time, this certainly is nature. On the other hand, nature for the first 4.5 billion years of Earth, except for that last few thousands or maybe even 100,000s, didn't reflect the presence of humankind, except in the ways other living beings, living animals might be protected with bones or fossilized evidence of their bones, or maybe some tools or shards. The International Society for the Study of Geology, you don't get a much harder science than geology, has accepted in its lexicon the term Anthropocene, some say Anthropocene, which is a layer in the crust of the earth that now and for the next million, or if we're fortunate, billion years, will reflect humankind's existence on this planet.
Wow.
Well, can you guys hear me? I wanted to say, what message should we take that here we are talking about Earth law, and Mother Earth is sending us interference with our man-made devices to remind us who is really in charge here.
So
She wanted to be heard and seen.
That's a fair point. That is a fair point. Well, thank you both for inviting us. I don't know if Tony's going to try to join back, but we wish you luck with the rest of your integrative law course. And I have to take off because I got a puppy yesterday. And so I don't want to put that whole responsibility on my fiance. So I'm going to head home and take over puppy duty. But thank you again for inviting us. And I hope the rest of you have a great rest of your day. And I look forward to staying in touch for the future.
Thank you so
And
much.
did we put up how people can connect with the Earth Law organization if they want more, especially since we had a sort of abrupt ending? Do we just Google? I mean, do you want to just for posterity?
Yeah, absolutely. So to learn more and to get connected, I would urge people watching this to go to earthlawcenter.org. And all the information is there. I know the Earth Law Center is doing a summer course by itself, an intro. And they've always got lectures going on and all different kinds of initiatives. So, and you can also reach out to one of us, and I'm sure we'd be happy to talk more or dive into a topic and give you more information. We're always available.
Thanks. Are you guys both still using your Quinnipiac emails, or?
I am not.
Okay, then put in the chat before you go. Put in the chat, and Aubrey, can you save the chat?
I'm not sure if I can, but if anybody reaches out to the Center Disprez email address, I can always forward the information.
Right. Okay, That's fine. That's a better way to do it. So,
Okay.
and Caroline, if you wouldn't mind putting your preferred email. So particularly people centric to Quinnipiac can reach out to you all, and other people listening can
Yeah,
just
reach
be
out
in
to
touch
Tom.
with us. But
Great.
Thank you.
Thank you so much.
Carolyn, thank you so much. I am so sorry about the technical difficulties.
well, you didn't hear my comment. My comment, Tony, is that Mother Earth was reminding us she can always interfere with our man-made devices. She is fully in charge.
I
And
love
although
that.
I take it that she's supportive of Earth Law movement, she just wanted to be present and accounted for.
I think you're right, Carolyn. Thanks for that spin doctor.
Yep. All right.
Bye
Thank
now.
you
Thank you.
also for the opportunity. We'll talk soon. Bye.
You all will. Thank you.